Hi, my name is Mari Bowie. I'm an attorney at the Nieves Law Firm, and today I'm going to talk to you about what is a motion to set aside. A motion to set aside is typically used in cases in order to set aside a verdict that is not favorable to that person. Now, it's not easy to get a motion to set aside. Typically, when a judge makes their decision, that is their decision and they don't change it. The only way that you can get the judge to change their mind is if you prove very specific elements in order to get them to set aside that verdict. And even once they set aside that judgment, it does not necessarily mean they'll grant it in your favor. All it means is you get a new hearing and you have to proceed that day, and you can still get an answer that you don't like. So specifically with the motion to set aside, one of the ways that you can get it is if you can prove that there was excusable neglect or surprise. It's important to recognize that this neglect has to be excusable. It can't just be like, I don't want to go to court that day. It has to be something that's excusable. I can't give a specific definition because it's going to fall into the umbrella of the judge. Maybe something like missing, or I had it on my calendar for the next day, like I had it for the 15th, but it was actually on the 14th. I can't specifically say if that's going to be a good excuse for the judge, but if you have record of that, you're going to have to be able to prove that to the judge. Now, in terms of surprise, that's different, right? Say, for instance, you have an agreement with the other party and they're like, oh, we're going to reach an agreement. You don't need to appear in court. So you don't, but then you find out that they lied to you and then they did all of these things. That can be a surprise, right? You didn't know that was going to happen. All of these things are specific to reasonableness. So you can't just say anything in that fly with the judge. It's not a subjective standard. It means that a reasonable person would have fallen victim to the same circumstance. The next way that you can set aside a verdict is by fraud, perjury, duress, mental incapacity, anything of that nature. So if someone, again, in the other scenario that I mentioned, if they lied to you, that's fraud, right? Or if someone perjured themselves and they lied and you have proof that they lied about something, that is also grounds to set aside the verdict. And then another way, and one of the last ways that you can set aside a verdict, is that you did not receive notice. So for instance, in every case, you need notice of what's against you. And if you don't receive notice of those allegations and you don't show up, then you can set aside that verdict because you did not have notice of the lawsuit. And that is, again, another way that you can set aside the verdict. There are various other ways sometimes that you can wiggle your way in depending on the type of judgment that you're looking to set aside. But those are typically the most standard ways that you can do it. And again, it's really important to recognize that just because you set aside a judgment doesn't mean that the judgment is overturned. What it means is you get a chance at a new hearing. Typically, the timeline is incredibly strict. You cannot wait longer than 6 months, and you have to prove your evidence because, again, once a judge makes their decision, they're standing on it. So you need to make sure that you have evidence to prove that it's reasonable and also to prove your point in order to allow the judge to set aside and allow you a new hearing. I hope that helps. If you find yourself needing a motion to set aside, please contact the Nieves Law Firm and see if we're able to help you.